the ASIM 2017 conference with Professor Gillian Triggs, who will be giving the keynote later this afternoon. She's going to tell us a little bit about that. But first, I'd like to ask you about the developments in marriage equality we've seen in the past week or so and the months that have preceded the debate. What's been your read on that process and how it's played out?
Well, if we think in terms of process, the process should never have happened. In other words, as a matter of international law, there is a right to equality before the law, and that is increasingly interpreted by courts and by the relevant human rights committees, also, of course, including the United States Supreme Court, as meaning that equality before the law requires equal access to marriage as a civil, secular institution. Therefore, if there were to be an amendment to the Marriage Act in Australia, that amendment should have been by our parliamentary representatives. So the first point is that we should never have had this process in the first place. But given that we've had it, and I think it's been very interesting that the yes proponents have, while objecting to the process, have said, right, well, it's an agreed matter amongst at least the parliamentarians, that they can agree on that much. We will now go along with that, and then they put their yes cases very convincingly, convincing obviously to about 62% of Australians. So for a voluntary, non-binding postal survey, this was an outstanding success for participatory democracy, and we got a very, very strong indication from the Australian public that they are well ahead in their thinking of their parliamentary representatives. So we've got to, in a sense, legally, in my view, the right result, but it's been a painful and inappropriate process.
So in terms of the process, is it a worrying precedent for you that we have taken this route?
It's very worrying because fundamental freedoms that exist in the common law, that have existed for centuries, the right to freedom of speech, to equality before the law, to freedom from arbitrary detention, freedom of association. All of these freedoms and rights are ones which have existed for a very long time, and they're not ones on which you have a public vote. They exist as an inherent right of being human, and that is the essence of human rights law, that you have these rights and freedoms as a human being, and they are not rights and freedoms that can be subject to the views of your fellow human beings. These are inherent rights, and that is essentially what the Universal Declaration of Human Rights declares, and certainly the more precise conventions on race, gender, disability, the rights of the child, refugees, and so on. These are inherent rights. They're not rights that should be voted on. And that's my concern, that having had this really remarkable and very welcome success, there will be a sense by some that every time we strike something difficult in relation to the human rights area, right to freedom of religion, for example, we have another postal vote. I mean, it's a ludicrous proposition. Now, maybe that I'm exaggerating the likelihood of this, I don't know, but I do think that having done it once, there's a very real risk that others will see it as a useful way of allowing parliamentarians off the hook. And I think that is a very dangerous abdication of responsibility by our elected representatives in federal parliament.
Mentioning something along those lines, and you did touch on mandatory detention. There's another human rights issue, I guess, that's making a lot of waves here at the moment, which is the plight of the men on Manus. Could you comment on what you think the implications of that, what's going on there are?
Well, the implications for Australia are that we are becoming a very mean-spirited country where we've lost the values that we used to have, that we built this multicultural nation on, and we've shown a flagrant disregard for international law and the principles that our forebears, Dr. Evatt and generations since that time, we've really trampled on that reputation and engagement with the international human rights movement that Australia has been a significant leader for over many, many years. At a more direct level, of course, the indefinite detention of people who are, for the most part, already assessed to be refugees on Manus Island in these dangerous and cruel conditions, as determined by United Nations representatives and UNHCR, it is a national shame and a national disgrace. And I think one can only hope, and I think this is an emerging sense amongst Australians, that we have to find a humanitarian solution to this problem. It's disgraceful that we're relying on the United States and New Zealand to do something about it, although of course we've put the New Zealand offer on hold, but there seems to be a glimmer of hope that it might eventually be accepted if the United States doesn't take as many as it has allegedly promised. But the key point, and my point, is that the responsibility for the typically young men, now about 600 of them, on Manus, although that number may actually decline a little, something between 400 and 600, who are left on the island. That responsibility is Australia's, and we must accept that we've sent them there, we've done financial deals to keep them there, we've controlled their lives in every conceivable way, and we've failed to provide durable pathways to settlement for them as they're legally entitled to.
Moving away from that, I guess, to your talk this afternoon, what, if you could take us just a bit through what you're going to discuss with the delegates today?
Well, of course, as an international lawyer, I'm not really familiar at all with the particular challenges that are faced by emergency medicine in Australia, and in order to prepare for this speech, I've informed myself a little better. And I have been very, very interested to learn about the particular skills that those working in emergency medicine need to have. They're quite an extraordinary range of skills in an urgent and sometimes chaotic circumstance. So I have been learning about those needs and also about the under-resourcing, the problem of the use of emergency departments in particular does mop up people who really should be dealt with through other medical facilities, and that is putting an enormous strain. The growing numbers of people coming into emergency departments is putting an enormous strain on doctors and nurses who are at the front line for many people, particularly those in aged care facilities and for those who are uninsured or who don't otherwise have primary caregivers. So I'm familiarising myself with this. But the primary purpose of my speech is to talk about the international human rights law standards that apply even in those urgent and chaotic circumstances in emergency services. I've looked at the standards that have been adopted by the College for Emergency Medicine. They're very comprehensive, very interesting. They respect the individual. They talk about the dignity of the individual and the importance of recognising privacy and autonomy of the individual. So in some respects, the human rights standards are picked up, but not explicitly. And I think one thing I would very much like to see is a much greater awareness of the Convention on the Rights of the Child, the rights of Indigenous Australians, to women, to the disabled, and all Australians, to the highest possible standard of care, regardless of their race or religion, of their financial circumstances, their education. These are matters that should and are prohibited as a matter of discrimination law, but I think perhaps that's not fully understood, and I think it would be helpful were those human rights standards to be included as part of the standards that apply in emergency medicine. But finally then, I'd like to really conclude by saying that we really do need more resources into training and into increasing the skills and staff in emergency services, particularly I think in rural and remote areas for Indigenous Australians, but it's true for those with disabilities, for women in domestic violence situations, sexual assault. There are many, many areas where we clearly need more resources and more training to be able to deal in a non-discriminatory and a fair way to meet that high standard of health to which every Australian is entitled.
And how do you see health and human rights intersecting?
Well, there is a human right to health. There is a human right to the highest possible standard of health, and that is the intersection. And I think most members of the medical profession would understand that, but they are clearly overwhelmed in a way by the sheer numbers, and they are advocates, of course, for change and for proper training. But I think my perspective is that this is a legal right, not something you do if you've got the time to do it or you've got the resources to do it. These are legal rights, and they should be legally enforceable rights in Australia. I also, of course, understand that even in emergency medicine there are problems of a lack of diversity, lack of opportunity for people from different races and religions and cultures. And I think that's something that needs to be addressed as well. But that's perhaps an internal issue for the College of Emergency Medicine. My primary emphasis is upon the international legal standards that apply to the delivery of health services to Australians generally.
And you, obviously the title of your talk includes a reference to vulnerable communities. Who do you envisage those people to be?
Well, it's interesting that almost all the work of the Australian Human Rights Commission tends, once we've done our research, tends to emphasise the vulnerability of particular groups, and they're almost always the same: women, the aged, people with disabilities, and people of different races and religions. And sadly, whatever we look at, including access to healthcare, the problems are the same. The people who have the least control, the least ability to manage their lives, the most vulnerable, and often the most in need, are the ones that tend to be at the bottom of the pile. And I think that's something we need to address.
And that's a phenomenon we don't only see in health, but more broadly. Why do you think that is?
I think it comes back to some fairly primitive ideas of lack of control, lack of financial resources, lack of opportunity, and to discrimination, frankly. So yes, this is well beyond healthcare. It applies everywhere. Education, housing, access to employment areas in particular that a human rights lawyer will look at. Of course, the Australian Human Rights Commission did and does. I think it's a phenomenon of human community life that if you are relatively powerless and poor and from more disadvantaged groups, that disadvantage tends to be compounded, and you find it in all areas, whether it's sexual harassment and assault in universities, access to employment, the workplace environment, and health. You find very, very similar patterns of disadvantage and discrimination.
And structurally, what can we do to change this?
Well, as a lawyer, of course, I have to say, and with some reluctance, I think in the end you have to use the legal system to enforce rights. And where you can't enforce those rights, then we need to legislate those rights. That's a start. The law is only ever a start. It provides the architectural foundation, but it can't do everything. But a major piece of litigation and successful case before a federal court or high court can be enormously powerful in changing things systemically. But there are other ways of doing it, and in addition to that, and they are cultural and regimes that we have at the Australian Human Rights Commission of conciliation processes. In other words, a complaints process, which can be done privately at no cost to any of the parties, but where you ensure or bring the parties together for some form of conciliation. We often found that, for example, insurance for people who are HIV positive, it's a health care matter, but it's a legal matter as well, and an insurance business matter. And in one case, we brought the parties together. The managers of the insurance company said, we don't like what this looks like, we don't like our own practices, we will go back and get different actuarial advice. And many months later they did come back and say, well, we've reformed our processes and we now will offer insurance to those who are HIV positive. Now that's an example of where you've got high caliber leaders in the insurance industry, in the delivery of health services, who are prepared to say, we want better outcomes, we're not proud of what we're doing, but it's not in the public arena, it's not splashed over the front pages of the major newspapers, it's something that we now have had a wake-up call about through the complaints process, and we will now achieve systemic change within our own organisation. Now sometimes that doesn't go far enough and we get further complaints, but they are ways of moving systemic change within the business community. And I personally, as President of the Commission, found that working with the business community can be very effective indeed, for all sorts of reasons, reputational risk, but also because I think with the younger generation pushing at leadership for change, that change can occur. Also, leadership now is inclined to pick up some of these issues and say, we're not proud of where we run this industry, we're going to do something about it. And these are very, very positive changes, which you can achieve without the legal standards, but it's far faster if you've got the legal standards and you've got the courts and legal decisions behind you. You only need one case with a big compensation payout and you find change shifts through the system.
Yeah.
So there are various ways of achieving this, but they're the key factors, I think.
And just finally, I guess we're seeing a bit of a public or cultural moment with the Me Too hashtag and the confessions of women, of men in power abusing their power. What are your thoughts about this moment and what it might mean?
Well, it's hard to know because we have been through some things like this before, and they're always exposés of one kind or another historically. And I say this as a 1960s feminist. You've seen it before, but this perhaps is more of an avalanche. It really does seem to have been something where the stone has created an absolute avalanche that perhaps is a little new. I'm hoping at least, and I think there's a reasonable chance that this will have an impact across the community, that a lot of men and women who've been abusers will say, actually, I can't get away with this anymore. It's not acceptable in the environment. I mean, and I don't want it to come back to bite me 20 years from now and destroy what would otherwise be a creditable career. So I'm hoping that it will start to have a genuine impact, but it is a very entrenched and difficult problem, deeply psychological and sociological, and I don't suppose an expose in the Hollywood industry is necessarily going to have is going to have an impact all over in other cultures, but I'm hoping it could be a leader.
Here's hoping. Thank you. All right.